Is to welcome you. I am not the reason you're here. I get that, but I do want to personally welcome each and every one of you to a wonderful evening. Relax, enjoy the conversation. And now I'll turn it over to Professor John Barrett, a member of our board and our vice chair of our programs committee, to introduce Linda Greenhouse. John?
Thank you, David, and good evening, everyone. There's literature and there are board members, and frankly, you might not even need all of that because the life of Robert Jackson becomes a bigger and bigger deal as it becomes, in fact, more distant. He's been gone since 1954, and when people ask me how is the justice, I do have to truthfully say better than ever, because he has turned out to be one of these lives, an American self-made lawyer, a leader of the American bar, a cabinet officer, the Solicitor General of the United States, a Supreme Court justice, the chief prosecutor and the architect of the Nuremberg trial, the best writer in the history of the U.S. Supreme Court, a lauded figure across contemporary situations for ranging from law schools to international tribunals to the bench of the U.S. Supreme Court. I'm Jackson's biographer. Many of you are victims of my Jackson email list, and if you're not, you're most welcome. And I have the privilege tonight of introducing someone who has been a very important teacher to many of us and a very important friend to the Jackson Center, Linda Greenhouse. And I have realized that as Linda made a few years ago a geographic transition in her life after 30 years covering the U.S. Supreme Court for the New York Times and moving north to New Haven, Connecticut, and joining the faculty at Yale Law School and doing really important path-breaking scholarship and, I'm sure, spectacular teaching. She's actually done something quite Jacksonian. You see, Robert Jackson is somebody we think of as Washington because that's where it ended. But of course, he was from a small town in northwestern Pennsylvania and then from western New York State and Albany Law School and practice in Buffalo and practice in Jamestown and briefly went to Washington. Never really thought it would be the rest of his life, but one thing does lead to another. And mentored and taught and worked with lots of young people. And what he always told people was, get out of Washington. Go to your country, go to your community, go to teach and contribute as a citizen. Now, Linda bogged down in Washington for 30 years and did her great Supreme Court coverage. It continues on the New York Times Opinionator blog. But in a sense, by leaving Washington and going to Connecticut and being part of the chapter that includes this great book and her historical work on Roe versus Wade and many other things that I'm sure are in the pipeline, what she's done is gone to her country and contributing as a citizen. And I think that's a great Jacksonian role model. Linda came to the Chautauqua Institution in 2006 and gave the second of what now has been 8 Robert H. Jackson lectures that Chautauqua hosts every summer on the Supreme Court of the United States. And frankly, she jumped that series into a major grant. Former Solicitor General Charles Freed will be giving the Jackson Lecture this summer, the 9th annual in that series. And it all kind of builds on what Linda started back in 2006. So with no further ado, on the topic of John Roberts and his court, it's really a pleasure to introduce our friend Linda Greenhouse.
Well, I'm not going to give a Jackson-type lecture, so those of you standing, don't worry about that. John stole one of my lines, which is what I was going to say, is that I know Robert Jackson, of course, just through his writing, through the Supreme Court opinions, and what John said is absolutely correct. He was the best writer ever to serve on the court. And for those of you who just want a sample and you're not lawyers or whatever, and pick up his dissent in Korematsu, the Japanese internment case, and just so many cases, and he just has such a way with words. So I can't say that I model myself from him in that regard, but in terms of returning home, I actually am from New Haven. I'm a returning townie. When I took my job at Yale, my husband and I both left Washington and are now teaching at Yale. And when people ask us, as they often do you miss Washington? The answer is no. No, quite a toxic place these days. So what I thought I would do tonight, since of course none of the important Supreme Court decisions of this term have come down, so they're all works in progress or works against progress or consider them. What I've done is written a little essay about last term's most important case, the healthcare case, with a focus on Chief Justice Roberts and his fascinating role in that case and raising some questions about, is it the Roberts Court? I just found, I expected that the court would uphold the law, unlike many people. I put my money where my mouth was. I wrote that several times in the column, the biweekly column that I write for the Times. I said that Chief Justice Roberts would assign the opinion to himself, of course, and that he would come out and uphold the law. That just seemed kind of obvious to me, but the way it played out certainly was not obvious. I would not have predicted that he would have joined the Commerce Clause analysis of the 4 justices to his right, or that he would go off on the tax issue. So I really couldn't sleep for days after the opinion came down. I was just so wired, and I even broke all my own rules of proper civil behavior toward people in high places, and I actually flat out asked a few justices to tell me what happened behind the scenes. I never did that when I was working there, and of course they said no, they wouldn't. So, so I'm not here with any inside information, but just with some thoughts that I've labored on for a while. So I will read my little essay, and then I will invite, for however long John would like us to go, your questions about the current docket and so on. So the lonely path that Chief Justice Roberts took in the healthcare case was, you might say, the Supreme Court's most consequential solo opinion since Justice Powell's opinion in Bakke a generation earlier, 1978, if you remember Bakke, the big affirmative action case. So there were 4 justices who said affirmative action never, and 4 justices who said affirmative action fine, and Justice Powell was in the middle, and he said affirmative action some of the time if it looks like Harvard. So, it wasn't that surprising to find Lewis Powell in the middle, because he was the swing justice of his time. He was the Anthony Kennedy, and before that, the Sandra Day O'Connor of his time. And you could say that his opinion in Bakke really, what is going on in this club? Bodies are falling. You could say that his opinion in Bakke have sealed his legacy as a Supreme Court justice. It came halfway through his 16 or 17 year tenure. So obviously the differences between Powell's situation and John Roberts' situation are quite obvious. The healthcare case came 7 years into the Chief Justice's tenure, which we assume will be quite long. Nobody had ever thought of John Roberts as a swing justice on the Supreme Court. And anybody who had any doubts about his non-swingness should look at what until this was his most important opinion, which was the Parents Involved case. Those of you who might remember 2007, this was the integration case from the public schools of Louisville and Seattle, where the Chief Justice said that quite surprisingly, in my opinion, that the public schools of Louisville, Kentucky, obviously a former de jure segregated school system that with great pain and federal court supervision and over many years had achieved a measure of integration which they were attempting to preserve with this very modest kind of student assignment plan. The Chief Justice said the city of Louisville had no compelling interest that would be served by trying to maintain integration. So he was way over on the right. He even lost Anthony Kennedy for that opinion. Kennedy, who's never in his entire Supreme Court career voted to uphold any government program that counts people by race, said, I'm sorry, it's not that simple. I cannot sign this opinion. Of course there's a compelling interest. He didn't like the particular plan. He didn't find it in equal protection terms sufficiently narrowly tailored to survive the constitutional challenge, but he said, I can't sign this opinion. So, that's where John Roberts was. I mean, he was to the right of even Anthony Kennedy in a very high-profile case. So So this was not obviously a repeat of Justice Powell's performance in the Bakke case. And of course, Powell wrote only for himself, and John Roberts in the healthcare case writes for 5 justices, the 4 to his left, in upholding the penalty, the mandate penalty, as a tax. So to that extent, it was a collegial effort. It wasn't a completely solitary effort, but no member of the court bought the logic in which he closed his conclusion, which was that because the mandate would fall to the constitutional Commerce Clause challenge, that it exceeded the commerce power of Congress, only because of an effort to save a statute, if it could be plausibly be saved, would he uphold it as a tax? None of them agreed with that, because the 4 who just wanted it to fall on the Commerce Clause were not interested in talking about a tax, and the 4 who joined him on the tax thought he was all wet on the Commerce Clause analysis. In fact, Justice Ginsburg's whole dissenting opinion from the Commerce Clause part of the opinion says, you know, what you have to say here about the Commerce Clause is purely gratuitous because you're upholding it as a tax. Why are you burdening us with your Commerce Clause thoughts? So also to that extent, this was not a Lewis Powell performance. And it is remarkable how alone, however, how alone he was. His part of the opinion, as the court issued it last June, was 59 pages long. And of those 59 pages, he spoke for the court in only 21 pages. And the rest was just his own effort to tell us what he thought. So Professor Erwin Chemerinsky of UC Irvine had a law review article that came out last summer proclaiming it's now the Roberts court. But is it, based on what I just said? Not exactly. Or not yet, anyway. Or is it? Well, we'll see. So looking at, I mean, there's many ways to look at the healthcare case from social policy and law, but because of where we stand or sit tonight in light of his forthcoming visit to the Jackson Center, my focus is on the Chief Justice. And to start with the obvious point here, this was not just any case. Aside from Bush against Gore, it's hard to think of any modern case that came to the court with such a clear political valence. And Bush against Gore, of course, was over in a flash. If you remember it, I'm sure you do. The Florida Supreme Court ruled on a Friday. The court issued the stay on a Saturday, granted review in the case. Briefs were due on Sunday. The case was argued on Monday. The case was decided on Tuesday. You know, they don't do that every day. Here, the National Republican Party has spent the 2 years after the passage of the Affordable Care Act staking its identity on opposition to the law and to its promise to have the law overturned either in court or in the next Congress. 27 states that went to court to have the law declared unconstitutional all had either Republican governors, Republican attorneys general, or both. And certainly one of the most amusingly disingenuous lines I've ever read in a Supreme Court opinion is this one from the dissenting opinion by Justices Scalia, Kennedy, Thomas, Alito. Why, they asked, have more than half the states brought this lawsuit? And the answer they gave to their own question was that it was because the law was so coercive against the states and so on. But the real answer, as surely these 4 justices had to know, was partisan politics. The court's own politically identifiable cleavage, already well established in the public mind by a series of 5-4 decisions with 5 Republican appointed justices on one side, 4 Democratic appointed justices on the other, had only served to heighten the impression that the Supreme Court was not only being invited to render a political decision, but was very likely to accept that invitation. A Kaiser Family Foundation poll in January 2012, soon after the court had granted review in the case, showed that 59% of the respondents believed that, quote, the justices will let their own ideological views influence the decision. Only 28% said they thought the justices, quote, will base their decision on legal analysis without regard to ideology or politics, unquote. A Gallup poll at the start of that term had shown a surprisingly steep decline in public approval of the court. down to 64% from 51% the previous year, and from the much more normal 61% 2 years earlier. Of course, that tracks in part a decline in public esteem for all of our governmental institutions. I think Congress is down. In one poll I saw 13%, one poll I saw 10%, so the Supreme Court is doing relatively better, but it usually was running in the 60s, and now it was down in the 40s. And that poll, people think, reflected the real partisan divide over the legacy of the Citizens United case. So these were two, the Kaiser poll and the Gallup poll, troubling measures of public confidence in the court and in the intellectual integrity of its members. And this could not have escaped John Roberts' notice, because he cares, obviously, as any Chief Justice would, a great deal about the court and what people think about the court. And he said a number of times that one of his main jobs is to leave the court in as good a position as he found it. So what is he to think about this? And so to make a second obvious point, that was not just any case, and of course, he was not just any justice. He was Chief Justice, and confronted with the most important decision of his judicial life. He was Chief Justice, and if he couldn't function as Chief Justice of the Supreme Court, that is to say, if he turned out to be a general with no troops, he must have decided, as the very tense spring turned to early summer and the country held its breath over this, that he would be all that his official title implies, and his official title is not Chief Justice of the Supreme Court, as Chief Justice of the United States. So with his usual ally seemingly on a partisan wrecking mission, determined to invalidate the entire statute by declaring none of it severable, and if this resonates with people, you know, the issue, the severability issue, is would Congress have intended that if a certain portion of the statute is unconstitutional, the rest of it is saved, or the rest of it goes down? And the four justices, the Kennedy, Scalia, Thomas Alito group, said that because they found the mandate unconstitutional, the entire statute with 1,000 other provisions would have to fall. And you can see John Roberts in late spring, at least in my mind's eye, I see him, his opinion started circulating, and the Kennedy group opinion comes in saying none of it's severable, and it all goes down, saying, huh? You know, I don't think I signed up for that. So as he sees this happening, he must have figured, well, he can't save the court from his friends, so he decided to save the court that he reveres by saving a statute that he clearly disliked intensely. His distaste for the Affordable Care Act jumps out of every passage in his separate Commerce Clause opinion. His writing is muscular, embracing the Commerce Clause attack on the statute in all of its colorful imagery, all of its reductios ad absurdum, if that's in plural. He says, for instance, quote, under the government's theory, Congress could address the diet problem by ordering everybody to buy vegetables. So he buys into, in published opinion, that whole broccoli nonsense. He says, quote, that is not the country the framers of our Constitution envisioned. By contrast to his 30 pages on the Commerce Clause, the prose of his 14 pages on the tax part of the opinion is flat, mechanical, almost apologetic in tone. He says, quote, it's only because we have a duty to construe a statute to save it if fairly possible that Section 5000 mandate can be interpreted as a tax. He says, Section 5000 is therefore constitutional because it can reasonably be read as a tax. And that's not ringing, that's not Jacksonian prose. So having imputed to Chief Justice Roberts the thought process for which, as I mentioned earlier, I have no direct proof, I'll take one more leap and suggest that had he been a mere associate justice, and a rather junior one at that, he might well have given his vote to the Commerce Clause for and let the Affordable Care Act fall. But as Chief Justice, he just wasn't going to do that. So assuming that the narrative I've offered bears some relationship to what actually happened inside the court, what are we to make of Chief Justice John Roberts? A brave, even tragic hero who took a bullet for the court, a, quote, strategic genius, in Jeffrey Toobin's recently published account in his new book, a sincere advocate of judicial moderation and pragmatism, learned, as my colleague John Fabian would suggest, at the feet of his early mentor, Judge Henry Friendly. A Reagan era as opposed to a new style conservative in the view of the political scientist Stephen Tellis. That is to say, someone with a genuine dislike of, quote, judicial activism, rather than someone who's happy enough to call upon the right kind of judicial activists when they might come in handy. Or is he a traitor, a turncoat, a type whom no respectable Republican president should ever think about nominating in the future, as John Yoo fulminated on the editorial page of the Wall Street Journal? A coward who abandoned principle and let himself be browbeaten by the liberal establishment, as anxious conservative commentators began hinting weeks before the decision came down, as rumors of the Chief Justice going squishy on them started to circulate. The vituperation unleashed on Chief Justice Roberts from the right was startling, bespeaking a sense of entitlement, of ownership betrayed. The howling tone was one of, how dare he? He's supposed to be one of ours. The attacks were deeply personal, and they raised the question of how the Chief Justice might respond, consciously or otherwise. Judge Richard Posner, a great judicial writer, one of my favorite judges, posed this question in characteristic pithy fashion in an interview with Nina Totenberg of NPR a few days as all this was happening after the opinion. This is what Judge Posner said. What's he supposed to think? That he finds his allies to be a bunch of crackpots? Does that help the conservative movement? I mean, what would you do if you were Roberts? All of a sudden you find out that the people you thought were your friends have turned against you, they despise you, they mistreat you, they leak to the press. What do? Do you become more conservative, or do you say, what am I doing with this crowd of lunatics, right? Maybe you have to re-examine your position, says Richard Posner. So where does John Roberts go from here? We've got a really tough term of the Supreme Court in progress. Supreme Court justices do, quote, evolve, history shows us, although John Roberts, with his inside the Beltway credentials and executive branch ticket punching, does not at all fit the mold of Republican-appointed Supreme Court justices who, since the middle of the last century, have sometimes trended leftward. And I wrote the biography of one notable such person, Harry Blackmun. I find it hard to imagine him becoming less conservative on the questions that seem to matter to him most: affirmative action, church and state, standing. But as the healthcare experience shows, the question is what conservative means, not as a set of abstract preferences, but as a prescription for judicial behavior, or more precisely, for behavior in the specific context. In listing the various ways one might understand Chief Justice Roberts, I've kind of held my own cards and failed to signal my own choice. As I suggested at the beginning, I actually choose none of the above. Not the hero, not the coward. Rather, I see John Roberts as having been carried along by events, or perhaps, to mix a few images, scrambling to get out of the way of an oncoming train while standing on a bridge over a fast-moving river. He jumped, and he came up still breathing, and good for him, and good for us. But does that make him the leader of a Roberts court? Jeffrey Toobin's new book, The Oath, offers a fascinating backstory account of how the Citizens United case came to be decided as it was, how it came to be re-argued. In this account, which I have reason to think is true, after the first argument in Citizens United, remember in spring of 2009, it was argued as a very narrow case. The question was, did the 45 or 90 minute, whatever it was, anti-Hillary Clinton film, was that the kind of electioneering speech that was covered by the bar on corporate sponsored electioneering ads on television? And according to this account, the court's answer was, no, it's not covered. Actually, I think that was right. And John Roberts assigned to himself the task of writing a narrow opinion to answer that narrow question. He circulated an opinion, but again, according to this account, the justices to his right were not happy with it, and Justice Kennedy circulated a much broader opinion that was a broadside attack on the whole McCain-Feingold law. And the other justices on that side of the street started migrating toward the Kennedy opinion and abandoned the narrow John Roberts opinion, so eventually Chief Justice Roberts said, okay, Tony Kennedy, over to you, and I'll sign your opinion, and that's what we'll do. At this point, the liberals on the court were extremely upset, especially led by David Souter, who said, this is outrageous. We didn't undertake to argue this broad question. The public's not expecting it. We didn't get briefs on it. And if you go ahead with this plan, I'm going to write a dissent that's going to blow the lid off the court. And by the way, I'm retiring. So at this point, again, according to this account, the Chief Justice said, okay, look, let's set the case for re-argument in the next term. We'll frame the questions that we purport to address. The public will be on fair notice. We'll get briefs, and everybody will have their say. And by the way, we won't have David Souter here to worry about. So that's what happened, and the rest of that is history. So Jeffrey Toobin proclaims that this scenario was a, quote, stroke of strategic genius by Chief Justice Roberts, but assuming the facts, and good for him for unearthing all this, I think a different assessment is called for. One that foreshadows what was to come 3 years later in the healthcare case. John Roberts wasn't in charge of the Citizens United narrative that I've just given you. He was carried along by it, riding a wave that he couldn't control. In his own separate opinion, concurring opinion in the eventual Citizens United case, he said, quote, there's a difference between judicial restraint and judicial abdication, was his explanation for what happened. And was there a hint of apology, even embarrassment in that? Or perhaps he was looking ahead to a future in which he now had some reason to believe his professed adherence to restraint would be put to an even greater test, to the test of his judicial life, to the making of the Roberts Court. So those are my prepared remarks. And I'm very happy to take this in a direction that you like and talk about court.
I'll break the ice. How does that then forecast a path for the Chief Justice with regard to the Voting Rights Act?
Well, so here they have the constitutionality of Section 5 of the Voting Rights Act. An accident that's been waiting to happen for the last 4 years, ever since they stepped right up to the brink in the earlier case. Based on their behavior on the bench, I think there's almost no chance that Section 5 is going to survive. And at least according to the way I parse out the various things that matter to him, this is getting rid of Section 5 of the Voting Rights Act, I think, is a core part of his agenda. I think he does have an agenda to get hold of government policies, statutes, programs, whatever that take account of race. He thinks we should all be beyond that. And I think the Voting Rights Act will go down, and I think that's an error of historic proportions. I think it's a really foolish thing to do. It's extremely aggressive. It gets at the enforcement clause of the 14th and 15th Amendments, in which the framers of those post-Civil War amendments gave Congress the power to pass legislation enforcing the guarantees of equal protection and the right to vote. It's not the court's business, and the court has made it its business. This was a purely discretionary act. This case, for those of you who follow this kind of stuff, did not, unlike the one 4 years ago, come up within the court's mandatory appellate jurisdiction. This was a totally discretionary grant of cert in a case that was ginned up by a network of right-wing foundations, mostly the Mellon Scaife group in Pittsburgh, put Shelby County, Alabama up to this. So it's not as if, the good fathers of Shelby County woke up one morning and said, let's challenge the Voting Rights Act. They're paid by these groups to bring this litigation. And it's really a bad business. And the court's stepping right into it. So it will be a very sad day when that opinion comes down, which I expect will be after his visit to Jamestown. Hope that didn't scare everybody. Strong message follows. But.
A year ago, I heard Justice Breyer speak, and he was speaking about, at that time, the respect for the court, generally speaking, And he said one of the reasons it's so respected is that it's not biased. They are a bunch of ideologues. How can we continue to respect the decisions that come down from the court?
Well, it's a challenge. I mean, I think they're playing with fire when they, undertake to do the business that belongs to the other branches. And I think it's very tricky, actually. They're in a tricky phase. And, Chief Justice Roberts was a SUMA graduate in history from Harvard. And, what he's about to do in some of these areas, in my opinion, doesn't reflect a very refined sense of history, actually.
So I have a similar question on the voting rights regarding the two marriage equality cases that were just heard a couple of weeks ago. But not just your sort of soothsaying about how you think the justice might ultimately rule.
I don't know.
Yeah, of course not. That's why I call it soothsaying.
Right.
But even more specifically, sort of, if you had a view about how broad versus narrow the ruling might be, whether it's simply punted by being dismissed on jurisdiction or standing on the Hollingsworth case. It's not as simple as how it's ruled, but whether heightened scrutiny is in fact going to be the standard for the case, which based on the justice's question, one might think he's not going to go there. So
Yeah.
what are your sort of views about those two cases?
So Perry, the Hollingsworth, the Proposition 8 case from California, does have this major procedural obstacle to getting to the merits, which is the standing of the Proposition 8 proponents. And I think the court will rule quite appropriately that this group does not have standing. You all know the background of this, that California declined to defend the law after the initial district court ruling, that not the law, the Prop 8, the constitutional provision, after Judge Walker and the district court has struck it down. And the standing of groups like this to take up the reins of the state is an issue that's been kicking around the federal judiciary for quite a while. It doesn't happen here in the East, but in the West, where they have all these initiative and referendum, legacies of long ago populism, and some of these initiatives and referendums turn out to be quite weird, and states decline to defend them. So what do you do? Does anybody have standing? So it's overdue for a decision, and we don't know what happened behind the velvet curtain that led the court to grant review in the Perry case. It was not the most obvious thing in the world to do. They had to take the DOMA case. Not necessarily the Second Circuit one, they could have taken the First Circuit one, but you've got a federal law declared unconstitutional by a federal court. The Supreme Court's going to take that case, that's why they're here. But Perry, having been a California-specific holding from the Ninth Circuit, really a lot of people thought it was not necessarily a cert-worthy case. And so, maybe they took it, they granted both on the same day. So as a pair, and there'd be a sort of off-ramp in Perry because of the standing issue. And we'll figure out DOMA as we may. I think I kind of have to look at them together, even though they each present different questions. It's most intriguing.
New York Times wrote an interesting article about that.
What?
Alito was behind it because he figured this was the best chance he'd have, time not being on his side.
Well, I mean, that's a whole other issue. So, right, time not being on their side because of the trajectory of marriage equality and of, gay rights in general. Time not being on their side if the Republican Party can't get its act together and put somebody in the White House who will be in control when more vacancies occur. I mean, not to sound totally cynical, but this is a court in a hurry. This is a court in a big hurry, and you have to wonder why. I mean, example, as you know, they have under submission now a big affirmative action case from the University of Texas. The case was argued back in the fall. It has not yet been decided. So a subsequent affirmative action case came in from Michigan, from the en banc Sixth Circuit, on the question of the constitutionality of a referendum that basically bars affirmative action in public institutions in Michigan. And the en banc Sixth Circuit, sharply divided, said this referendum on kind of political process grounds was unconstitutional. So this comes in. Now, in any normal behavior of the Supreme Court, that cert petition would have just been put on hold while they sorted out what they thought about affirmative action in the Fisher case, which is first in line. And that's what they do. They put all the other possibly relevant cases that come in the interval on hold, and then whichever justice writes the opinion in Fisher then writes a memo to the conference suggesting what should be done with all the held cases and so on. They didn't do that. They granted the Michigan case. They granted it without Fisher being decided. Now, why? This is a great mystery. So, the sort of obvious answer is they're not getting what they want in Fisher. That there weren't 5 votes in Fisher to take affirmative action down to the ground, because you don't have to do that to overturn the Texas 10%, not the 10%, but to overturn what Texas is doing in a kind of Texas-specific way. So let's make sure we have ready to go as soon as possible the bigger question. So they are a court in a hurry. I'm scared everybody. Sure.
There's a lot of concern about Roe v. Wade, its possible overturning in some way. Also, many of the states are legislating laws that seem in great contradiction to the Roe v. Wade. Do you believe that the states will be so persuasive that the court will feel it has to change its point of view in some way?
Actually, no. And on the right to life side, the intellectual heavyweights on the pro-life side are quite upset with what's going on in the states. It's not coming from them. And some of these bills that are being passed into law are so outrageous that there's not a chance that the Supreme Court would uphold them. And instead, it sets up it almost calls for the defense of Roe from people who wouldn't even care to defend it for just on judicial process grounds. I mean, it's obvious that the notion of barring abortion after 6 weeks, as in North Dakota, is not going to stand. And in fact, the governor of North Dakota, in signing the bill into law, said, it's good that we're passing this. It will be challenged in court. It's going to take a lot of money to defend it. And we have so much money right now because of the natural gas and all this stuff that's going on in North Dakota that we're going to be the state that is going to spend the money to defend this law. So, it's hard to take it terrifically seriously. Now, there's some other laws that may well be upheld that could have a bigger effect because they're not so in your face, such as these laws that are being passed to say that doctors who perform abortions at freestanding clinics cannot do that unless they have admitting privileges in a nearby hospital, and so on. And these are things that are much more kind of in the weeds, but can really affect accessibility to abortion services. And that's a concern, but these are not cases that are going to lead the court to overturn Roe.
Thank you.
The question is, of course, what
That's
what
good.
good is Roe if all these obstacles, are enabled to come in? That's a different question. Yeah.
And I'm a baseball person, and you are the biographer of Justice Harry Blackmun. Talk to me about Flood versus Kuhn, and after the decision and all the litany of baseball players, did he discuss that whole nostalgic trip down memory lane, baseball, that in your readings and papers, kind of post Flood versus Kuhn reaction to his own decision?
I hate to disappoint you, but actually, no.
Linda, can you make it up?
No, he kind of moved on to things that were more lasting interest in him. So, So I guess for that, I'd say, read the opinion, which is a trip down memory lane. But I don't really know of any kind of secondary literature on it except some rather biting critiques of it as judicial crap. But you can read it for fun.
It is.
Linda, how much have you seen in the court, within Roberts' court, and you feel, to the extent that maybe Roberts is a pragmatist in the way maybe Black or Brennan was, in understanding what really goes on in situations that affect the law, and that he puts himself into that situation and tries to understand that a little bit more and comes to a decision based upon that?
Actually, no. Is he a pragmatist? I think he's got a project, and he's looking for cases that will advance his agenda, and he'll take them when he can. On other stuff, of course, much of what the court does is pretty much bread and butter. So I think about 40% of the court's cases every year are unanimous. It doesn't mean they all agree with everything, but they just don't think it's that big a deal. So, you can make him look pragmatic depending on, which end of the telescope you're looking at. But I think on these high-profile cases, I'd say in that box.
Let me switch to the person to the chief's right. Justice Scalia occupies Justice Jackson's seat by heredity, and he identifies Jackson as his hero. Is Justice Scalia what he's always been, just a more senior version, or
Or is he losing it?
or has he changed? Or has he changed?
A little bit.
I never like to kind of pretend to know more than I know, so I actually don't know. But certainly, he seems to have abandoned a certain filter, a certain situational awareness, and some of his rants are a little surprising. And his comment from the bench about the Voting Rights Act and perpetuation of racial entitlement. It's interesting. I mean, that was not in his interest to have gone off like that, because actually Shelby County, the Voting Rights Act case, was getting pitifully little attention from the public. The marriage cases have kind of sucked all the air out of the room of this term. But Scalia made these remarks, and all of a sudden, it's editorial cartoons, and people are talking about it. So, he doesn't seem very strategic. And you remember his rant from the bench the last week of the term, back last June, on the Arizona immigration case, where he basically took off on the president for the DREAM Act, amnesty, partial amnesty for children who have been brought in, young people who have been brought in as children. It had nothing to do with the case. In fact, that whole thing came even after the Arizona case was argued. And Scalia just started ranting about it on the bench. It was, kind of surprising. So your question is very well taken, and I don't have a definitive answer. I just have anecdotes.
Please join me in thanking Linda for these great
I'm the president of the Robert H. Jackson Center, and I certainly want to thank everybody for coming this evening. It has been a wonderful evening. As we are a nonprofit, I do want to thank a few of our hosts for the event tonight, and for thanking them for opening up and helping us put on this event this evening. And that is in 3 of our board members. Of course, the Honorable Judith Kay, Joseph Zanetta, and our board chair, who you met earlier, Dave Crane. And I want to thank them for hosting the event this evening, and thank you very much. I would also like to thank the firm of Phillips Lytle for providing the Linda Greenhouse book here tonight, and thank you very much. Personally, I'm going to ask her to autograph my copy, but But if you did not pick one up on your way in, please, there are some more on the table outside. Please feel free to pick one up. John earlier mentioned the Jackson list and John's emails that come out about Robert Jackson. If you are not getting those emails and you would like to, if you have not put your email address on the list outside, please do that on your way out. And we will make sure that you get on the Jackson list and receive John's emails, as well as updates about the Jackson Center. And so please do that. Lastly, I would just like to say again that, of course, as our chair indicated at the start, we are very fortunate to have Chief Justice Roberts visiting the Jackson Center for a public address from the front porch of the Jackson Center on the morning of May 17th. And the Jackson Center, in line with our mission to promote the legacy of Robert H. Jackson and to educate everyone, in particular children, about the lessons coming from Robert H. Jackson. We're very much looking to make this an educational event. And we've invited the schools, and we expect thousands of school children to come to that event that morning. And we've had interest from schools all over the region. But just to give you an example of some of the things that we are putting together in anticipation of the Chief Justice visit, you will find on the table, and there are more out here, a pamphlet. And if you look at this pamphlet, you'll see that it is geared towards high school level students, junior high level students, to talk about the Supreme Court, about Justice Jackson, and of course the Chief Justice. So please, if you have not picked one up off the table, please pick one up on the table or out on the table outside, as well as you'll find a Jackson Center update in front of you. But again, we thank you all. You don't have to rush off. I hope the bar, yes, I think the bar will still be open for a few more minutes, so you don't have to rush off. But again, thank you all for coming, and we would like to see you all become supporters of the Jackson Center. Thank you very much.